I recently submitted a brief to support Parliamentary Committee on Justice and Human Rights in their debate on the Miscarriage of Justice Reviews, Bill C-40. I said, thank you for this opportunity to continue to contribute to the advancement of the better administration of justice. I am in the unfortunate position of having informed the legal system of problems in the administration of justice, which has resulted in retribution, which reflects poorly on the constitutional requirement for fair and impartial trials. My experience included a lawyer committing fraud on a court order and a refusal to comply with a court order to provide monthly trust account statements, evidence of tampering and trial fixing. I reported the problems to the BC Law Society, and the lawyer involved admitted to the default in writing and pleaded for mercy. There was no hearing, and the matter was dismissed by the benches with no discipline whatsoever and a refusal to provide written reasons for their decision as required by the statute of the legislature. How can Canadians trust this relationship critical to accessing justice? Unfortunately, the judge who presided over the trial was Justice Shaw, whose fitness as a judge was debated in the House of Commons in early February 2002 with near unanimous condemnation. However, they almost all folded their position when the Minister of Justice, Anne McClellan, pleaded with them to permit the justice system to resolve the matter internally. Unfortunately, a local judge had seized himself of the trial, and there was no explanation for why he was not in attendance, and the police were informed of substantial removal of documents from the court file and redacting of all references to failures by the lawyers to comply with court orders. There was no investigation conducted beyond interviewing me and dismissing my concerns as being paranoia. A complaint was made to the Canadian Judicial Council of Judge Shaw's behaviour at the trial, where, when presented with the transcript to conclusively demonstrate the fraud perpetrated on the court order, he called upon the plaintiff and requested she provide testimony and preferred that to the best evidence that any Canadian could provide. The Council approved of the conduct as complying with the good behaviour constitutional requirement. How does that judicial conduct comply with the Judges Act, Section 80? The judge's continuation in office would undermine public confidence in the impartiality, integrity, or independence of the judge or of their office to such an extent that it would render the judge incapable of executing the functions of judicial office. Specifically, Category D. The judge is in a position that a reasonable, fair-minded, and informed observer would consider to be incompatible with the due execution of judicial office. The Council dismissed the complaint without examination as being one of judicial discretion, as if discretion is absolute and not bounded, when the acceptance of the transcript is a duty to protect Canadians to their right to access the public service of justice. I subsequently made a complaint to the Council regarding that decision, which the lawyer assigned to reviewing complaints dismissed as an abuse of process, instead of following the Council's procedures to send complaints regarding members of the Council to an independent lawyer for independent advice. Despite reminders, this has never been resolved, and further communications with the Council remain unanswered. I properly served the enforcement procedure of the Charter, Section 24(1), upon the Attorney General, Minister of Justice, which failed to generate a response, including a response to a constitutional question on the matter, which continues to remain unanswered, and subsequently an explicit refusal to respond to the constitutional question on the constitutionality of ignoring a constitutional question. The concern is a lack of regard by the administrators to deliver the public interest in a legal system that provides justice, complies with the constitutional constraints and procedures. When I presented these facts and lots more before the BC Supreme Court, including a request for a writ of mandamus on the Minister of Justice to comply with his duty to protect the public and ensure that the administration of justice was in compliance with the law, my experience was dismissed as irrelevant, and subsequently for a right to appeal to the BC Court of Appeal, where my lived experience was not only irrelevant, but a conspiracy that does not reflect reality. I should note that the decision to deny the writ of mandamus, the judge did not appear at court. The date was February 14th, 2022. The Minister of Justice on that day issued the invocation of the Emergencies Act. The reality of the consequences of that decision confirmed that I have no rights in the BC courts, as everything I say can be denied as a conspiracy theory and given that the Judicial Council claims discretion over all evidence, the legal system is arbitrary and worse. I was subsequently incarcerated for 80 days with a refusal by all lawyers to represent me and no ability to appeal the decision, as the incarceration occurred immediately. I did, however, submit a habeas corpus application on the Supreme Court Canada, which was ignored for over a month, until a complaint to the Canadian High Commission in Australia by my parents generated a response from the court that termed my habeas corpus application a letter in denial of Section 9 of the Charter, arbitrary imprisonment, and Section 10C, the right to habeas corpus. I can confirm that there was no legal advice available through the Prison Legal Service on habeas corpus applications at all. The Prison Law Library had no Supreme Court of Canada decisions in its legal database, only Western provincial decisions, which for my purposes were irrelevant. If the Canadian Judicial Council approves of judges ignoring the best evidence that any Canadian could provide, then justice is subject to every whim and bias of a judge and offends Section 9 of the Charter. The problem appears to be that judges are not competent at fair and impartial judging of their own conduct and that of the conduct of lawyers. That should have been apparent long ago, as it is a well-established principle of fundamental justice that no one can be a judge in their own cause. The desire to assert the important separation of powers doctrine of judicial independence forgot that the principle exists to protect the public. During the debate on the Bill C-9, the Judges Act in the Senate, I proposed amendments that would correct the deficiency, but that it appears that government refused to accept most of the amendments suggested by the senators. My proposal was that judicial conduct should be examined by a jury as a bulwark of individual liberty and the reality that judicial conduct can only be legitimately examined by the citizen, whom they purport to serve. I informed both the Speaker of the House and the Committee on Procedures and House Affairs regarding the problems in the administration of justice, and requested procedural details regarding the process to follow to request Parliament to assert its constitutional responsibility for peace, order, and good government for Canadians. Parliament is the penultimate protector of the liberty of the citizens of Canada, and the separation of powers doctrine requires checks on the legitimacy of the claims of constitutional compliance by the judiciary. Proc never responded, which is somewhat understandable given that the Minister of Justice's legal advice is to deny the enforcement procedure of the Charter, which creates a constitutional crisis, as the Executive claims it is not bound by the procedures of the Charter and have refused to justify that conduct in a free and democratic state, as required in Section 1 of the Charter. It is not fair to subject Canadians to abuse by lawyers and judges and provide them with zero ability to protect themselves. This is a responsibility of Parliament. Law societies are a creation of the provincial legislators with the protection of the public interest as their primary objective. But the Judges Act and the Supreme Court of Canada Act are the responsibilities of the federal Parliament. If there are no protections for the public, then they have no purpose. Having a judge or a lawyer check for situations of false imprisonment does not properly check the powers of the judiciary. On a personal note, I should not be incarcerated for telling the truth about my bad experiences in the legal system, requesting accountability and transparency and constitutionality to be rigidly tested and enforced according to the established legal rules. We are supposedly guaranteed these legal rights. I wouldn't return to a store that didn't honor their guarantees because I have other options. But the legal system is operating a monopoly, and Parliament has a duty to enforce the terms of the guarantee upon the judiciary. It is one of the core responsibilities of the Executive and the House of Commons. Failure to do so constitutionally should result in the dismissal of the Minister of Justice and the Prime Minister. That is how important upholding the rule of law is in a democracy. They hire them, often based on political affiliations, probably political bias, and the Minister of Justice has the responsibility to request Parliament to fire them for failing to provide their constitutionally required good behavior. The best solution for democratic deficit is to reinforce democracy. For the current bill, it would be important to have a citizen jury at the head of the process in order to protect the public interest. The jury system is well respected as a bulwark against a biased, overzealous, or vindictive judiciary. Thank you. The last thing that anyone who has been wrongfully convicted wants or should be subjected to is to submit themselves to a judiciary that denied them on typically multiple occasions. That is abusive. I will not voluntarily submit myself to that abuse under the current regime. Parliament has the ultimate responsibility to protect the public interest from abuses of power by the judiciary or the executive. Thank you.